It feels different. Es que es distinto. No importa si estás en Saturno, en la Tierra. Al final se necesita una buena charla con un amigo, especialmente if he happens to be an expert. Quien la apueste, at the end, it's all you can get.
Welcome back to season 2 of All You Can Debt. We're here with Mehak Rashid from LegalScale. Mehak, thank you for being here.
Yeah, thank you guys for having me. Always a pleasure to connect with experts like yourself within the debt space and talk about topics that we're all thinking about.
Great. We'll love to hear like a little bit of background on you, your career, to kind of give the audience a sense of all the interesting perspectives and insights you'll be able to bring us.
Yeah, absolutely. Like Tom said, and thanks for the intro, my name is Mehak Rashid. I am a partner and co-founder of LegalScale, and I head the debt finance practice there. So we've had a terrific time working with Vaas previously on a number of our different transactions. And by way of background, I started at Davis Polk previously, founded LegalScale thereafter, have been practicing debt financing for over a decade at this point, and really focusing on different types of transactions. But I think the most important thing that I think I bring to the table is the concept of not only being a lawyer, but being a partner on these transactions. So giving the business advice as well as legal. And I'm able to use my JD MBA in respect of that concept and making sure that we're actually being advisors to counsel. So I'm excited
I have a question.
Yeah.
I have a question. So I feel like the debt structured world, it's something that it's not out there. It's like, it's not a career that you choose. It just like kind of finds you. Do you remember how it found you? Or do you remember how your first deal went? Like, do you remember like that first moment?
Yeah, it's funny because it does actually stick out in my head pretty substantially. You know, early in my career, I was actually doing a lot of M&A. I put debt finance as like one of my lowest ranked things that I wanted to do. And then I ended up trying it out and I immediately just fell in love with it. What I really liked about it, and in particular contrast to M&A, was that it wasn't a zero-sum game. So it wasn't like if somebody wins, the other person loses for sure.
It didn't feel like barbarians at the gate.
Exactly, right? It's more like we're creating a deal. And my favorite type of way to describe a debt document is that it's a living document, meaning that it goes on forever. And you guys, it's not like, you know, you buy the company, you're done and move on, but for some things here and there. This is something you have to live with for a long time, and the relationships are the most important thing. So there's a reason why I knew I never wanted to go into litigation. And then there's a further reason why I really like debt finance.
Which was?
That
in addition to the fact,
you know, you're making deals. It's great. You're creating more into the ecosystem. People are happy when transactions close, and everyone on both sides is happy to have that, either capital drawn or capital received, and growing the business, growing the funds, etc. So I personally really enjoy it.
Do you remember your first deal, what it was? What kind of asset or what kind of project was it?
You know, it's funny because when I was at Davis Polk, we worked on a lot of very large transactions. I think the largest one I worked on was like a $10 billion transaction with like senior facilities, second lien, mezz, etc. But that wasn't as interesting as one of the first ones that I worked on, where it was the 12th amendment for that credit facility. And it was like a small facility, but the borrower kept being in default. We kept needing to give covenant holidays or interest period holidays, and we kept needing to amend the facility. So it was a great way for me to learn how does PIK work necessarily, and how does that provide leverage to the company to continue business? How does a company that's distressed look, rather than, you know, all the hunky-dory, totally performing companies that is just the same facility over and over again. That was my first foray into complicated structures and really understanding the company.
And I have a question, because this has been kind of a common theme that we've run into, is thinking about what's going on in private credit right now, especially with some of like the frauds that have happened in the market, and us moving more into the US and having more conversations with lenders, lawyers, differences between the structured credit market in Latin America versus the US. And I think you have a really sort of deep, unique perspective on that, having worked on a lot of cross-border deals, including ones with Valentina. So I would love to hear just in general, to kind of start, like, get a lay of the land, like, what are the major differences in Latin America and working on deals there versus in the US? And do you feel like there's some sort of shift or such a change in the dynamics and the differences?
Absolutely. And I've definitely worked with Valentina on a number of these kinds of transactions. And the hardest part is definitely structuring. But I do think that a lot of countries in LATAM have created a tried and true structure that's able to provide the security for the lenders and also make things more streamlined for the borrower. So the difference that I think of is in the US, there's a lot of just SPV borrowing. So you create a Delaware LLC and drop that under whatever company that you have your equity raise at. So usually a Delaware corporation. And then that SPV is the borrower under the facility. And we have a lot of protections in place, which is fantastic when it comes to, for example, having account control agreements over all of the deposit accounts of the company. You can have a third-party servicer of the asset, so it's not the company itself servicing the asset. But I think one thing is you're still relying on the company itself to function as, staying compliant with the covenants that you've put out, providing reporting as well on a regular basis. And then if things go sideways, you definitely have the protection and the full force of the bankruptcy court to assist. But at the same time, it's not as great as having a totally third party that has administered this loan from the beginning. So that's, I think, the difference is in LATAM, like a lot of countries, like Mexico, especially Colombia, for example, they have a trust structure set up where all the assets, they aren't even held by the borrower. Trust itself holds these assets. So enforcement is much easier in that respect. And I think that came out because originally enforcement would have been much more difficult had the assets been held by the Mexican or Colombian companies themselves. And putting them into a trust makes it so that these lenders feel more comfortable with lending against these assets and whatever remedies that they may need to exercise upon a default and exercise of taking over the collateral. So that's one thing that is definitely different. And I think I'm seeing a lot more creep into the US of creating these trust structures rather than just having an LLC acting as the borrower. But I'm sure you guys are seeing that as well.
Yeah, so let me take a step back. Do you remember what your first transaction in LATAM was, or your first cross-border transaction?
Well, before LegalScale, we had a few cross-border transactions, but at LegalScale, I would say I think one of our first ones was probably working on that PageWay transaction along with our Architect Capital. And there was a lot going on in that transaction for sure.
Was that the Colombian one or the Mexican one?
It was the Mexican one, because then the Colombian one came a little bit later.
Came afterwards. One of the things that you mentioned is, it feels like, or at least my interpretation is this way, it feels like LATAM is catching up to the structures, the US is catching up to the structures that LATAM has. But if we talk about specifically one fraud last year, Tricolor, they had a trustee in the middle, right? So where do you think the benefits are of having a trustee, seeing it from the perspective of like what you've already seen in LATAM and what you've already seen in the US?
Yeah. I mean, I think part of the problem with that Tricolor transaction was the double pledging that occurred, right? And when I say part of the problem, that was the problem. So what that led to was just inappropriate calculation or figuring out what the assets look like. And then that double pledge is certainly what created issues where one lender thought that they were getting the benefit of these assets, another one thought the same. And so I think, that's why companies like yours, Vaas, come really into play by providing the actual underlying value of the assets, like calculations on a regular basis. And that information is crucial. Just recently, I had one company that I was representing the lender on for financing. We were going through the whole term sheet and had signed the term sheet. Then later on, I find out through the market that company was also setting up a sister company for another financing through another lender. And so thankfully I was able to find that out, because exactly the same problem of, were they going to tell us about it? No. we're going to find out about it? Potentially not, unless we ran lien searches or something like that. But even then, it might not show up on our entities that we were financing. So thankfully, I was able to get that. And then we had it subject to the ROFR that we had included for additional debt. But had we not figured that out, easily could have been the case where this company was double pledging their assets, creating another tricolor situation, and then our lender wouldn't be able to get the proper recovery on those assets. But I think, to your point, Valentina, if there was a trustee in place, I think that we just need to have better controls and reporting. And what I do suggest to lenders generally is doing periodic lien searches on their companies so that they can keep up to date, even outside of what's being reported to them, but rather on a public record at all times.
Do you think that if the lenders or whoever had the ability to do searches on Tricolor, had they done searches in the UCC, do you think they would have found out?
It's hard to say without knowing exactly like what the original lien searches looked like and what where they were actually placed.
Walk us through like 3 different examples where perhaps they would have found out and perhaps where they wouldn't have found out. Like, let's create like 3 different scenarios.
Yeah, it's a great question. So one, absolutely, if there was a lien on our SPV that was acting as the borrower, they would have absolutely found out because it's easy to run those searches. You can see if they filed it. Funny enough, the one in between, so that's absolutely, and then there's one that's absolutely not. But the one in between is, could we have found out? Now, let's just say that the SPV also took out an additional debt, but the second lender never put a UCC filing in place. We would not have found out, even if you run a lien search. Now, having said that, that means that their lien would not have been perfected, but they would still technically have a lien. So they would be like an unsecured creditor, let's say, against that SPV. But that's still not great to have that in place, right? And then the third of not finding out at all would be if, let's say that there's the parent corporation and then our SPV financing, and we don't have anything at the parent corporation in terms of debt, but they could drop another SPV here, and that is where the lien sits. We have no knowledge that that SPV exists, and we usually wouldn't have restrictions on the parent to not create new subsidiaries. So we wouldn't even know if a covenant's been violated or if there's that lien filed against a new facility. So even if you run searches at the parent level and you run them at the SPV level, you could still not find out. And that third case is what I was talking about earlier, that the only way I found out was through, honestly, like just seeing activity on LinkedIn and seeing what is happening in the market and then finding out and investigating a little bit further.
So this actually brings me to 2 conversations. Let's talk about the one that you mentioned regarding you're not filing, you do have a security, but it's not perfected. How does the law handle? So let's say if I go to bankruptcy, typically what would happen? Basically, you just become an unsecured creditor and you just like, you have to wait for the judge to say, hey, you're eventually going to get paid. How does that typically get handled? You do have a security, but it's not perfected.
That's exactly right. So there's 2 steps to create. Actually, I should say there's 3 steps to a lien. There's 1, the granting of the lien. 2nd, the filing of it. And 3rd, basically what leads into the 3rd, which is perfection. So first you have to have some sort of collateral grant. And what that means is I can't just file a UCC1 on Vaas and say, all assets you ever own are mine. If you didn't sign an agreement with me to grant your security interest over your collateral, that is null and void. People can file it, but it has no backing, right? So the first is to definitely have that security agreement. The second is to then have the proper UCC filing. So what that does is it puts the public on notice that there is a lien over your assets. And that's why there's always a section for the actual description of the collateral, so that if anybody were to do public searches, which anybody can search on the UCC register, then now the public is on notice that there is a lien in place on this entity for this particular collateral. The UCC is very particular, as well should be, that if you have a couple things wrong, even if, let's say, the comma is missing in the company's name, it's incorrect and you can't actually use it. So it's not a perfected lien, which is why it's
Wait,
so
let's
important.
differentiate it.
Yeah.
I can still file it, but then the judge is going to take it down, or the UCC, the system won't work. What do you mean by that?
No, the first one. So it wouldn't be an effective filing against the company if the name of the company is incorrect, if the secured party's name is incorrect, and the address of the company is incorrect.
But
So
the UCC won't necessarily like check that for you automatically. You have to wait basically until the judge gets in for you to basically
correct.
be 100% sure. Okay. Very interesting.
Yeah, and honestly, like you could be 100% sure when you're filing by getting the certificate of formation or organization from the actual register at Delaware, for example. You can get those certified copies, then file it accurately. And that's really, really important why we check all these things before we file, because otherwise the UCC is not going to be effective. And you don't want to find that out should there be a bankruptcy filing at that point.
So,
But yeah,
you do the security you do the security agreement that has to be mutually agreed to, because you cannot just one party do it. The second one is you do the UCC one, make sure you file it correctly, and you do that by asking for certificate of incorporation, et cetera, and you make sure. What would be the third step?
The third step is doing post-closing searches. So what that means is you guys have now filed, you're good, you've granted the security, you've perfected the security, so you have a solid lien. The third step is just a check to make sure that there hasn't been anything that was filed in between when you had, let's say, closed and then actually filed your UCC one, because there's a concept of first in time perfection where, let's say that, okay, today's May 18th. Let's just say somebody entered into a security agreement with me right now, and they entered into a security agreement with you, and both are valid. But you file your UCC one before I do. You are first in time, so you're technically senior to me on the filing. So filing right away is also really important.
One of the things that I sort of started differentiating as looking at different systems was whether it was a registry to be a very specific to one asset. And so on an asset level basis, you're doing that, and there's like a database to do this. And then there's another type of like database, which is more like what UCC looks like, or what RUG looks like in Mexico, or what RGM looks like in Colombia. But there's different types for all different types of assets. My question specifically is, where do you see that the pros and cons of having this system, right? So what are the pros of like you getting a really good description down in the UCC versus the cons of like, hey, you don't really have like asset by asset, or like the atomic level, as we call it in Vaas, the atomic level registration? Where do you see the pros and cons of having those systems?
It's a great question. And every country differs, right? So like you said, like RUG could be over movable assets or non-movable assets. So there's a differentiation there. Similar in the UK, for example, you can have different kinds of indentures that are either where you can add to the assets generally without amending any of the filings, or you have to do it on an asset by asset level. So the pros, let's say that we had a blanket lien, meaning that it covers all the assets of the company. The pro of that in the US is that you can you're done, right? Exactly. Like you file it. Easy peasy. And so there's no argument there whatsoever. The con of that is if somebody is searching and they find this UCC and it just says all assets, but let's say that they had an equipment lien for particular assets, maybe we need to figure out ways to have that carved out from the all asset lien in order to make sure that your equipment lien is senior to that, right? And so to flip that around, if you're only financing particular assets, you're much better off having a very, very particular UCC filing, meaning that you say, see Schedule A attached for all the assets. And then we've done GPU financings, we've done car financings, we've done different kinds of movable assets like that, where we include, like for cars, their VINs and other descriptions. For GPUs, we include their serial numbers. So all these things are super important, because what that does under the UCC is actually make that more specific, so it sits senior of any of your all asset liens. assuming that everything's appropriately carved out of the security grants.
If I were to use an algorithm to optimize my collateral, would that be cherry picking?
So I actually think it's maybe even thinking about it a different way is to optimize an algorithm to randomize it so that you keep randomizing between the allocation, and what your inputs and outputs should be is focusing on the financial covenants in each of these facilities. So making sure that you're, well within less than one standard deviation between the two asset classes, especially if the eligibility criteria, let's say, looks the same between the asset classes.
What
So the
happens if
goal
it
being-
doesn't? So I'll give you an example. What happens if one lender says, hey, the advance rate for everything less than 30 days is 90%. But then I get another one that says, hey, if it's less than 30 days, I'll give you 95% advance rate, right? So 5 different. Now, if I optimize my collateral for, hey, everything that is less than 30 days, it's going to go to this one because it gives me a little bit more. Would that be cherry picking?
So that's exactly the problem that we come up against. Is if I were in the lender's shoes, I would say yes, that is cherry picking. But at the same time, if I'm not getting credit in the borrower's shoes, if I'm not getting credit for any of that, then it just sits in your eligibility criteria, but you're not even assigning any credit to the borrowing base calculation. So what does it matter to you whether I take it or not? But that is one conversation. Another one is like, what are the rest of the economics, right? So like if you're getting a lower interest rate from lender 1 versus from lender 2, you have more of an incentive to borrow more from lender 1. So you want to put more of the meatier assets into lender 1. But that is exactly where we come out. So I think there's a couple ways to make it more fair, right? One is totally random allocation. Another one,
No
that we've
optimization at all. You're leaving money on the
Exactly.
table 100% of the time.
right. And no one can argue that that's not fair because it is totally random. Now, is it fair to the borrower? That's a different question.
Is it fair to the equity holders?
Yes, exactly, right? So that's a different question. But what we're worried about here is a lender calling a covenant failure for no cherry picking, right? Now, another way that you can combat that is potentially doing like a round robin structure where you, as assets come in, and this is more, I would say, not for folks that originate like 7-day assets at a crazy pace, but rather like longer dated assets at a slower pace. But let's say one asset comes in, you allocate to lender 1. One asset comes in, you lender 2, and you keep going amongst the lenders, or you have some sort of like, we allocate the next assets up to 3 million in origination to 1, and then the next 3 million to lender 2, and keep going backwards and forwards like that. That it seems fair on paper, but then, there's cyclicality of businesses. So maybe assets originated January through March might look different than April through June.
Maybe. Yeah. I think that the blanket statement of cherry picking is a little bit outdated for the new types of structures and everything that is going to come in now. For instance, like whether a GPU has been used after inference.
Right.
So like if it's been used already after X amount of time, then maybe that is cherry picking in itself. What I think it needs to be very clear is that what is there's the blanket statement of like, hey, cherry picking, don't do it. I think it's incredibly hard to determine whether you're doing it or not. And I think if you are a borrower who is actually doing it, not cherry picking, but if you do have an algorithm to tell you, hey, this is the way in which you're going to settle assets, or you're going to sell, or you're going to allocate assets, I think that algorithm should be clear to all of the lenders. I think that provides transparency. You know what I mean? Because I do think it's fair to the borrower that it's not taking advantage of the terms that it's negotiating. It shouldn't say, I got this from JP Morgan and therefore I'm going to give you this. No, not that. It should be like, hey, I'm going to tell you what my algorithm it's doing. Just like an allocation of payments, right? Like if you're going to have like FIFO or whatever you do, like you share that with the lender. You should do that as well in terms of allocation. And I have not seen the industry at all whatsoever moving into that transparency at the algorithm level.
Yeah, I totally agree with that. It makes sense from the borrower's perspective for sure, but also to your point earlier, it is helpful to the equity holders because they're not just sitting on assets that aren't getting any value under these facilities, nor does that zero asset value help lender 1 in that scenario either, right? So it's
Yep.
not helping anyone, it's just hurting the company at the end of the day.
Yep.
But
Yep.
to your point, like it definitely needs to have full transparency. And then no matter what, I'm sure there will be fist fights here and there as
Oh, yeah.
they go.
Oh, yeah. Tom, you had a question.
Yeah, I wanted to go back a little bit to talking about like Tricolor, First Brands, and kind of like the post, I guess, like world, what it like looks like afterwards. What are the specific kind of questions you're getting from clients, specifically lenders, on, oh, now they realize that there is, potential issue with collateral fraud or even operational errors that cause like issues that you just don't catch. So what are the questions that you're getting, and then what are the responses, I mean, that you're giving, and sort of like how can you prevent this from happening to you? We talked a little bit about lien searches, talked a little bit about, trust structure in the middle.
Yeah, I actually wanted to ask a question, but from a story perspective. Do you remember as soon as it happened, were people calling you? What were the first questions that they were asking? Do you remember like how it has changed from like, I don't know, 8 months ago up until now? I can't remember when it was.
Yeah, I think it was in September. Right, yeah, exactly. I think a lot of what they were asking was exactly that. Like, how do we know if there's other debt that's in place right now? And then how do we know that the reports that we're getting from the companies are accurate? And so what ended up happening was a lot of folks started to say, we're going to use our right to implement a third-party servicer. So like a backup servicer that was cold previously now is hot and is actively like doing all the reporting and the information providing to the lender in respect to that. So that definitely changed. And then I saw term sheets change from that, where it wasn't a cold backup servicer anymore, but rather like from day one, they were going to have this in place. So that's definitely one way that the lenders were saying, this is how I'm going to get protection. Because also just thinking about it from a litigation perspective, if this third-party servicer messes up, there's another pocket that the lender can go after if there's like gross negligence, misconduct, things like that, that's outside of a potentially bankrupt company as well. So that also added more comfort to the lenders. But yeah, there were a lot of questions that came up right after that.
Did they ever ask you like who's responsible for rechecking that, or did they know that they had never like do you think that it was like like the industry in itself didn't know and they were confused, or do you think that some percentage of them did know, hey, we don't have this in place and we knew that this could eventually happen and we're just getting up until that point? Where do you see like that crowd?
I think it was actually the latter, where a lot of lenders realized, especially, I should qualify this as like private credit funds that are lenders within the space, that especially might be just on their first or second fund, right? So smaller lenders that don't have huge established teams, they realize that one analyst that they hired can't handle all of their transactions, and realize that they need to bring in verifiers like Vaas that are verifying these things on an outside basis, that aren't looking at it as just something to do, but rather like this is their job. This is what you guys do. This is what you focus on. And providing that top level information is really helpful for these lenders. So a lot of folks realized that, that little MBA grad that they hired to do all the work on these facilities isn't going to cut it necessarily. So rather than building up their own teams internally, they started to outsource a lot of this. And so I think part of it was shaped. Yeah.
Whether they had the time or not, think that there's a lot of information that it's not disclosed to the lender, where even if they had the ability to do it, they didn't have the data to do it.
Mm-hmm.
When I first started Vaas, I knew that the borrower had to gain something from Vaas in order for us to get access to the data that they were not even previously willing to share with the lender or even the servicer. Like, for instance, we get 100% of all the documentation. We get 100% of all of the payment data, which we'll talk that about in a sec. But you mentioned something very interesting, which is the role of a cold backup servicer. What in the US, what does a cold backup servicer do on a, let's call it month to month or annual basis? Is the answer like nothing? Or is there something that they do while they're cold?
Yeah. I was going to kind of ask a question very similar, and I don't know, it just sounds kind of funny. So like, it sounds like very, very much so that it's ideal to have a hot backup service. it kind of doesn't even make sense to have a backup servicer if it's cold. But
Tom,
what
did I tell you something? I'm not sure if I ever told you this, but in LATAM, we don't have one, maybe just one, but actually no. We don't have any transactions where we are cold backup servicer without us being a verification agent in the middle. Meaning I won't ever take a deal blindly because I know when shit hits the fan, like getting access to that information, it's going to be incredibly hard. And guess whose name is going to be in that paper when things come up? It's like, oh, Vaas, but then you have to explain that you were a cold backup servicer and you didn't have access to any information. And so now you have to have 3 months. And it's like, well, if it's hard to get access to the information, even as a hot backup servicer, now imagine going from cold, freaking freezing, all the way to getting like you're already like getting burnt by the sun because now like everyone is looking at you. So that is something that, for instance, I didn't even realize where the US was just like even further away than I thought of.
And when we like talk to servicers, specifically like third party servicers about this, I mean, one of their kind of issues is thinking like, all right, hot backup servicer, mirrored backup servicing is like expensive for us to actually operationalize. So we have to like charge a higher cost. So do you think the creation of this sort of like range with like warm, like in the middle is to partially prevent costs? Like what are kind of like the issues that I guess lenders are running into if they're like, oh, we want a hot backup servicer, but we don't want to impose additional costs to like maybe potentially lose a deal if we're in the middle of negotiating it to a borrower? Do you think that sort of like dynamics in there where it's like cost, it's also difficulty of like onboarding and implementing like a hot backup servicer? Is it like the servicer might not actually be able to get access to data anyway? What are kind of the dynamics there, like creating this range and making it a little bit more complicated than maybe it needs to be?
It's a great question. And I think that the warm backup servicer is a product of exactly what you're mentioning, where borrowers are often saying it's too expensive. Why are we needing to outsource this? I promised you that I'm going to provide you the reports. You're going to get all this information. Why do I need a backup servicer? And then on the flip side, everything's hunky-dory when people are entering into a credit facility. Like money's on the table. Everyone's excited. It's going to be the best business in the whole wide world. And then when things go totally sideways, everyone's like, why didn't we get this in place when we closed? Right? So it's definitely a cost thing. And what I've seen to try to bridge the gap is a couple things. So one is that they're trying not to lose the deal on the lender side. So they'll give some post-closing period to get a backup servicer in place. So it's not required for closing. So, the company wants money right away. They want to move the deal quickly. And a lot of times lenders win on how quickly they can move on these transactions and close. So they'll say, okay, fine, we'll do a backup servicing as post-closing. So that's definitely one thing that I've noticed. Cost is definitely much more expensive for a warm servicer versus a cold. But to both of your points, like what's a cold servicer worth in a situation where now the company isn't performing well? They're not going to comply with you. If I had a borrower tell me exactly this, he said when I was telling him that, hey, if you don't do XYZ, like you're going to compound on your defaults. And he goes, well, what does it matter? If I'm already in event of default, then I'll have 3 events of default. Like, what do I care? So it's hard to argue against that because technically he's right, but like, do you really want to do that? It's difficult to work with borrowers at that stage where things might be not going well at all. And so an alternative I've seen as well is no requirement for a hot or warm servicer, but we have the cold backup servicer. But let's say that there's a covenant failure at any point and we need to give a waiver. That waiver is conditional on changing the backup servicer to warm. So I think that's pretty smart and strategic because it addresses our concerns where we're kind of getting, it's like the canary in the coal mine, right? We're understanding that the company is about to be in trouble. We're giving them a waiver and then protecting ourselves from the lender's perspective.
That comes with conditions.
Exactly. So that's one way to fix it. But then at that point, like it's hard for the borrower to argue that, no, I don't want to do it for cost purposes. It's like, well, we're in a scenario where either we waive this default for you or we don't. And this is the condition to waive it.
A very particular point of view here. I want to read you something where we were at Private Market Forum like 2 weeks ago in San Francisco. This guy, Mark, he just produces like incredible events. We love going to his events. And they asked a question about like,
this is not a paid advertisement for
this is not a paid
Private Market Forum
advertisement.
events.
Really, I just really love his events and how he thinks of private markets, etc. The question was, let's start with the problem and what you're building to solve it. So first of all, I would love to get your opinion on this. I want to get your opinion. So let's start with the bigger problem. They asked this question to us, right? Let's start with the problem we are building to solve it. Where do you sit? What is the biggest challenge facing private credit market participants when it comes to managing and scaling complex facilities? Platform doing about it. And let me expand on this question. One of the things that when VCs ask me, like, how do you think you win the U.S. market, or how do you think that you get in, etc. And often my answer was like, I think you will only be able, or I only think that Vaas will be able to gain this market only when shit hits the fan. Because before that, our value proposition, which is building infrastructure, people are building this infrastructure on trust. So let me show you my answer, and I would love to get your opinion. So
Yeah.
I actually think the challenge is incredibly simple. Lending used to happen primarily inside the banking system. Today, a huge portion of lending happens outside of it, whether you call it private credit, shadow banking, embedded finance, or even parts of decentralized finance. The important thing is this. Banks didn't just have capital. They had decades of operational infrastructure, risk management systems, regulatory pressure, auditability standards, asset liability management frameworks. Entire muscles that were built over time, sometimes by regulation, sometimes by surviving crises. A lot of the non-bank world inherited the assets, but not the infrastructure. And I think the biggest challenge in private credit today is that people assume the operational maturity of banks translates one-to-one into non-banking lending platforms. It doesn't. Although I don't want to say it like that strong, but mentally it feels like the trust, it's sort of translated. Many of these platforms have never truly been stress tested operationally. For example, if you had to continuously sell pieces of your portfolio into the market, would the data hold up? Would ownership be clear? Would cash flows reconcile? Would investors price the assets the same way management does internally? Those are banking grade questions. And what we're building is infrastructure that helps bring banking grade verification, monitoring, and operational trust into markets that increasingly move. Let me add one thing. The question that I still don't have answered is, who's responsible if shit does hit the fan systematically? Who is responsible at the bank and also at the private credit funds? Who's ultimate responsible? Who's ultimately the person that you blame because this is part of their job? And that is something that I still have yet to find, which is who's the actual, if you're a banker, you have pressure to close, you need to deploy the deals. You don't have a counterparty or someone who's countering. And is that the risk management department? Is that the operations and back office? Is there like a KPI for this? Like, who's ultimately responsible today? Where if shit hits the fan, like, who is supposed to be like looking at this and pressuring for these things? That is the one thing that I have not been able to find, which is who's ultimately responsible. I mean, yes, you could call it the CEO or whoever, etc. But like within the organization, who's ultimately responsible for safeguarding, for in the lookout for these things?
You know, everyone's gonna pass the buck, right? So they're gonna say, I did my part, it's on this other person. I did my part, it's on this other person. But I think there is multi levels here, right? So the first one being the person that pitches the facility in the first place internally. They have to have a real understanding of the assets that they're financing. If they don't understand them, so for example, a simple thing like, do you know that these assets turn over every week or every 30 days, as opposed to these are like 180-day loan facilities that are receivables? That mismatch of like asset liability mismatch is important for these people to underwrite. So if there's a misunderstanding at that very first level, then I would say the person that brought this deal didn't fully understand what they were doing. The second person is probably a collection of like the credit committee, right? Because they are being presented all the facts at that point, and assuming all the facts are correct, right? So that goes back to number one. Assuming all the facts are correct, the credit committee decided that this is a risk they're either willing to take or is not enough. The risk doesn't go outside of their box. So if things continue to perform as the facts say that they would, and they still go belly up, then we know now there was a fault with the credit underwriting. And then the third one I would say is the constant monitoring. So who is actually in charge of this portfolio? I had one lender tell me that he went out on paternity leave and came back and all of his portfolio was like in defaults or going sideways. And he's like, what happened? And it was because, he wasn't there to monitor. And that is super important because even if you have an idea of what this looks like in the regular reporting, you can't just blindly turn in something and say, this is what it is. You have to look at the actual reporting and say, this is a red flag or a yellow flag. And if you don't raise those issues, anyone that's at the senior level that's getting those reports without those flags isn't going to raise those issues either. So I think there's a trifold here of when the deal goes wrong and why the deal goes wrong to then look at. And the easiest thing to do is to do a post-mortem, right? You're never going to know and predict the future in advance, but you can always look at and learn from your past mistakes to then make sure you don't make those same mistakes in the next 100 deals that you do.
Something before we let you go that you had a very strong opinion on that was very interesting. And that's specifically, I think you put it as the biggest gap you see in private credit today. And that has specifically, to do with physical possession, and going back to the UCC, you thought we were done, you thought wrong. So talking about Article 9 versus electronic stock certs and other things that Article 12 is supposed to account for, but want to hear your full kind of view on that. I think it's something that everyone needs to hear.
Yeah, absolutely. I mean, the big hot topic these days is what happens with shares on electronic services like Carta. I'm just going to use Carta as an example because it's quite widely used, but there are other stock certificate holders like that as well. So in the olden days when people still used this weird thing called mail and physical printouts of everything.
I thought you were going to say paper.
Yeah, exactly. So what we used to do, right, is have, let's say you have a Delaware corporation, you have a physical stock certificate for what you own, and if a lender was providing a loan up against that stock certificate as collateral, the lender would hold that stock certificate along with an undated but signed stock power. So if they needed to exercise remedies, take control of the company, they'd date that stock power, take control, and we'd be all set under the UCC. So when we were talking before about the grant of security under the UCC and then perfection, what perfection means for this physical collateral is possession. So that possession is important to have because otherwise you're unperfected against this stock. Now we get into a weird situation where in the last, let's say decade, there's now electronic stock certs. So there used to be a bifurcation of stock certs. One was either physically printed stock certs and one was uncertificated. There was no in between. So if it's uncertificated, you're perfected under the UCC. If it's certificated, you're perfected under the UCC through possession. So that was the way to go about it. Now we have
I'm not sure
in between.
Not sure I follow. Before we continue, Mehak,
Yeah.
I have a question. So what happens is there this concept of double pledging a stock certificate and therefore because in UCC 8 you still have not perfected it publicly that maybe someone else has that same stock certificate, but because you did it first, is there something, I don't know the equity world that well, so is there something along those lines where you see a possible issue, or that gets solved in a very completely different way?
So the benefit of having a physical stock cert is that no one else can have it. So if you actually hold it, then you can't technically double pledge it. And then in the uncertificated world where there's no physical, that just goes down into the UCC, like the first in time to file, like we talked about, the grant itself. And so that's just held like any other perfection and lien priority that we have for other collateral. So that's where now you bring up a great point. Because if you have an electronic stock cert, what prevents you from printing that out 10 times and giving it to so many people, right? So,
and then you file it first, and what happens at that point?
Yeah. So this is where the law isn't totally clear and needs to be updated. But this is a way that we've figured out how to do it and aligns with best practices with a lot of different law firms is you have the stock cert in Carta. You can download and send that over to the lender. Then we've created two things. So one is we still have a physical stock power. So similar to what you would have for an actual stock certificate, you still have that stock power. And you also add in, let's say, a covenant that you can't like double pledge this, right? So the problem there being that that's a contractual remedy, not like a physical thing. But if you're not able to trust someone in a transaction, it's hard to enter into the transaction with them in the first place. But let's just say now this third step is what really brings it home, and it's very difficult to get, and I'll tell you why. But have an agreement with the issuer that puts the issuer on notice that the lender has a lien over this stock, sir. So let's just use, let's use Apple as an example. Big company, you have a stock.
Okay, yeah, let's do a public one and then a private one. I would love to do it with like Apple, and then let's do it with like OpenAI or Anthropic. Did you see the Robinhood, how they are doing those things? So feel free to choose.
So big public company, right? And the borrower is, let's say, against their stock. So you want to make sure that the lender is protected against their stock. So in that scenario, there would have an agreement with Apple and borrower, so a tri-party agreement that tells Apple, hey, by the way, this is subject to our lien. So if the loan goes into default, we're going to take control, and you agree to transfer this stock over to us if we submit to notice to you.
Is that Apple who controls it, or is there like a third party that controls the actual certificate? Like is there like an infrastructure provider that does that?
Yeah. So in large public companies, there are companies that hold they're intermediate securities companies, and that makes it much easier because they actually will control all of this, as opposed to, let's say, Carta, for example, where there's a lot of private deals. So they will have the physical stock certs, and it's much easier to deal with. So you don't necessarily even need to, in a public scenario, enter into that company issuer agreement acknowledgement with Apple. So that's easier. But let's shift to private now, where there's a private company. Sorry, before I move on, one thing I would add to the public company is you're never going to get Apple to sign an issuer acknowledgement, right? There's just no way to do that. So the only way to do it is by having like an intermediate securities holder that has the stock and pledges it. And large companies like that typically do have certificated pledges anyway.
Maybe it becomes part of their service actually, and they charge for it maybe, and yeah.
Exactly. So it's much easier in that sense. But then flipping over to private companies, so that issuer acknowledgement is still important, but reason why we get a lot of pushback is, one, let's say Anthropic, right? It's pretty large, where they don't really care about borrowers borrowing against their stock. They're not going to give that the time of day, but that prevents us from getting actually in contract privity with them. So it creates a difficult situation where you have an electronic stock certificate, you have the covenant in place to restrict the borrower from complying, but you don't have a remedy where you can go to the issuer and say, transfer this to me. And when that happens, it's also because most likely the borrower didn't tell the company that they're pledging their stock, which is also problematic. Right?
Yes. Yeah, indeed. And I actually wonder what's going to happen now with because when Robinhood launched this, they launched it with OpenAI, and Sam Altman came out saying hey, none of this, we're not validating any of this, but I wonder what's actually going to happen, when people are borrowing against it, or maybe they're selling it multiple times, and what is going to happen in these cases?
Yeah, to use a technical term, be a shit show. So, I think part of it too is we definitely want to have those technological control agreements, like we try to call it under Article 12, for example, is just having some sort of third-party agreement. For example, and this is, I think, the closest analogy under the UCC, is cash. So cash in accounts is, you can file a UCC1 over the cash for sure, and that'll control it. But how do you perfect it? You only perfect it if you have a control agreement over the account that is holding the cash. So it's very similar here. You really can only perfect it if you have the ability at any point to give notice, just like you would do under a deposit account control agreement. You give a notice to the bank and say, I'm taking control of this account. Similar here, you would give notice to the issuer and say, I'm taking control of the stock. So that's the best way, and the only way that right now under the framework that we have that we can provide that. coupled with the blank and signed stock certificate, stock power, and the covenant is as much protection as we can possibly create. But, if there's ever a situation of double pledging or whatever else, at that point we get into fraud territory, which sometimes just gets outside of the four corners of our document.
Okay. And so let's talk, for instance, about invoice factoring. If you were to structure one today, how would you think about it?
Yeah, so invoice factoring would fall under Article 8 and Article 9 because it's essentially a title to those receivables. So it's a contractual agreement so it would fall under like intangibles, where essentially it is the actual contract rights, the contractual rights that you're receiving and financing against. So it's not electronic necessarily because there's a physical contract that's been signed.
Okay, that's where I just get so confused. It's like, wait, if an invoice is digitally created, and then the contract by which we're signing it, let's say it's DocuSign, I don't see any physical paper. Everything it's electronic, right? Well, why would that still be under Article 8 and 9?
Because it's a contractual right. So it's not about the method of signing
Okay.
the contract itself. And on top of that, we actually put all this language within our credit agreements or everywhere else, and you'll see it. It's like electronic signature contract language, which basically says if it's signed through DocuSign or something else like that, it acts as if it were an actual signature. So that language has allowed DocuSign to really take off, and a lot of these electronic signature companies to work within these contracts. So it's not necessarily about like how things are signed, but rather what is the underlying asset itself. So here it's a receivable for invoice payment, right? And that's why the Article 8 and Article 9 that we already have governs not only the lien itself, but the perfection as well of the actual underlying asset. So it's like a sale of accounts, payment intangibles, promissory notes, things like that Article 9 specifically already covers.
And so, but let's say if you're doing a smart contract where I'd say, hey, Mehak, I'm going to give you $1,000 and you give me $1,500 worth of Bitcoin. A smart contract, you still need to sign some kind of way, even if it's through blockchain. But the signature method, if it's irrelevant, then why wouldn't Article 12 would Article 12 not be covered, would invoice factoring would not be covered under Article 12 because it's very specific during Article 9 about which type of assets? Like, I guess my biggest question is, how do you know by a fact which asset it's governed or which asset is governed or which type of transaction is governed by the two different types of articles?
Yeah, no, that's helpful. So I think part of it is definitely the underlying asset that you're financing, right? Like, are you financing a payment itself? And usually that payment is not, let's say, in Bitcoin, but let's assume it's wires, cash, whatever else. So that is just a payment intangible that you're financing, and that's why Article 9 covers that. But then if we start to get into the idea of securing against the payment mechanism, so if you're talking about you're securing against the Bitcoin or the blockchain access, that is what will be governed by Article 12. So it's about what are you trying to get security over? Are you getting security over the payment stream, or are you getting security over under the actual asset of Bitcoin, let's say? So that differentiation matters as to how the perfection is actually conducted. I would also caveat all that with Article 12 is pretty new and people are still trying to figure out exactly that type of perfection. In fact, today I reached out to a law firm to try to do some regulatory work where the underlying asset is crypto, and they came back and they're like, we don't do crypto. So there's a lot of pushback right now because it's so new and everyone's trying to be first to be second in it.
That's interesting. If I don't have this just makes me have 10,000 more questions, which is because imagine if I have a smart contract, right? Technologically able, but I have a perfection over an SPV. And then that SPV holds invoice factoring. Then do I need to have an Article 9 or like a UCC1 registration for that SPV? And then do I need Article 12? Because then, you know what I mean? Like, it's the underlying asset of this SPV, it's invoice factoring. But then when I create a smart contract that it's over this, that it's basically collateralized, but all of these things, then applies Article 12. Then the thing is, well, you need both. In those cases, does that make sense? That's where I'm getting very confused.
Yeah, I guess I would take it a step back, right? So a lender wants to perfect in their security interest. What is their security interest?
Yeah.
Governing. That is the invoice factoring. What the
Yeah.
company itself is factoring is a different thing. But if there was an exercise of remedies by the lender, what are they going to try to do? They're going to try to step into the shoes of the company, take over those invoices, and start to relegate all the amounts that come in directly to them. So they're not technically securing themselves under the crypto that is paying these invoices. They're securing themselves to be able to step into the shoes of those invoices. So that's the difference. And that's where the line should be drawn as to, like, if you're thinking about a doomsday scenario, company goes under, you're taking over the assets. What are you secured against? What are you stepping into?
Yeah. That it's very, very interesting. Have you heard about the Clarity Act? I don't know anything about it. Apparently, like, it's the thing that will change completely the game. I'm gonna have another what is it called? Like another invitee? How do you say it, Tom?
Guest?
Yes, another guest who is like all in about the Clarity Act. So I guess I'll tell you more once I know.
I love to keep up to date on these things too.
Tom, any last question to close?
No, I mean, I think this has been an awesome conversation. We covered a ton of ground. So, Mehak, thanks so much.
Yeah. No, thank you guys for having me. Thanks for reaching out. This is always great. If you can't tell, I love to talk, so I'm always happy to hop on these things, and especially to create content like this and co-branded stuff between our companies. Like, I think we're very complementary in the services that we offer, and somehow we run into all the same companies all the time anyway, working across from each other. So I appreciate all the time.
Who do you think it's your ideal customer? Who should reach out to you to work with you guys?
Yeah, I think a lot of private credit funds are fantastic to work with because we work with a number of them, but not only can we help them on the debt finance side, but then also on the fund side. So we have a pretty strong funds team that can navigate the most complex structures and assist with that. So I love those companies. And then I also really enjoy working with borrower side companies that maybe, let's say, are raising their Series A, Series B. Then our excellent equity team can come in and we do those things in tandem with debt facilities. So frankly, I just love people that want to make deals happen, and I'm always happy to be in the room with them.
Well, I would recommend anyone who is very keen to talk about the structures. If you want someone to like I always remember you as someone that probably that I wouldn't talk to you, but like Jimmy would talk to you all the time, and you guys would go back and forth and figuring it out and like just like a lot of like figuring it out. So
Right.
like that type of partner into structuring, I think it would be great for them to choose you guys.
Yeah, I appreciate that. And that's exactly what I was saying at the top of this as well is, we try to not just be boring lawyers, which I'm sure I am, but also adding the additional structuring concepts and figuring out a deal to make sure that it works from the perspective of everything's great and
Yeah.
also from when things go sideways, how to protect everyone's interests properly. So that sounds fantastic, and, always looking to work more and more with Vaas.
Mehak, it's a very nice conversation. I loved it. I wish that as cases come up, we can discuss them again live and what new laws are going to be established. And I don't know. I just love talking to you and walking through the different issues. So I appreciate your time coming up into the All You Can Debt podcast with Tom and I.
Amazing. Thanks for having me.